the KIMs have reported. So when all the KIMs had reported, because this is a snapshot of that information in time, when all the KIMs had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that polling station we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deploying of infrastructure and the servers platform. They did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there is no agent, Justice Mulu asked, if there is no agent, what happens? The integrity, the processes that we have in terms of the KIM's return, in terms of the portal, even if there is no agent, we can actually confirm what happened. So it's not the role of even if someone said I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have, go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that. If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate, 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the IBC logo in the background, both images. To 2 days. Actually, you can check all the edits.
Sorry, Council, you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave two examples. If you can just go back, I think I'll start with the first one. The 185, yeah. If you can go back. And you're using the same that the IEBC PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's no any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong. The exact same fold. It's an impossibility. I mean, you have 41 polling stations all over the country, and the form they are giving is at the same elevation as what we have given. The picture that our PO took on the background of the Kim's kit is the same. And you can tell, and the reason why we were saying that it's an impossibility is because there's nothing else you can change from those forms. You cannot change the signature of the agents. It's an impossibility. The only thing you can change is the tallying. You can try change into JPEG and try to amend the tallying. And that is really important. That is the crux of this matter, and the court has to look at that and actually make a finding. I will try to also to Justice Ouko's question about the stray ballots. I just want to mention that the court report bears out the assertion of the IEBC. If you look at the report, I put in the polling day diary, PhD. I have provided the polling day diary for 2 of the constituencies to just give the court comfort that as IEBC we can account for each and every ballot. To the question that has been asked by Justice Wanjala on the turnout, a clarification was given, and this is the assertion of the petitioners. They are saying we are not interested in the clarification given by the chairman. We are going to take that turnout of 65.4 as against the total registered voters. Okay, then come to the conclusion that there are votes that are unaccounted for. And we are telling him that is not how we do it. Okay, turnouts we give the number of people who either have passed through that kit at a snapshot. Okay, and there's nothing much about it. The declaration is made on the actual physical ballots that we count. We count the physical ballots. After counting the physical ballots, we tally it. Madam DCJ asked about the rejected ballots, whether they are different from the rejected. So the way we calculate turnout refers to the number of people who have passed through that polling station in the 46,229 polling station in the Republic. We have not even reached the issue of rejected ballots or anything. It's how many people appeared that day. So we have a number. Then we do the counting. After counting, we get rejected ballots. So how do we determine 50 plus 1? We will say, okay, what are the total votes cast? And we will refer to the 2013 and 2017 decision of this court that said rejected ballots are not a choice of preference and the same have to be removed. So the idea that turnout is affected by rejected ballots or doesn't matter, it's just a measure of transparency. And you have to understand how the reporting of the KIMS happens for you to be able to do. We only give what we can at the time, and we'll keep on doing that. With those
Thank you, Councillor. You're not even being heard. But thank you for answering our questions. On the kit, please deal with the registrar of the court. Thank you for your assistance. Your time is up.
My lady, I do not know whether you can give me 2 minutes to respond to Lady Justice Jokindong.
You're not helping me to do my day's work very nicely.
I'm sorry.
But 2 minutes would mean 2 minutes.
Yes, please.
So that you don't go away saying you are not heard.
Thank you very much, Deputy Chief Justice. The Honorable Justice Jokindong wanted to know from me of my personal experience as a draftsman of the original Constitution, what our intentions were when we created independent commissions. And my simple, straightforward answer is, we were trying to create greater autonomy and functional independence. You would achieve. The one thing we achieved is that we created independent commissions that do not function in the same way. For example, this commission, the Electoral Commission, the chairman has executive authority, because this is one of the very few commissions where the commissioners themselves do some actual work. This is very different from EACC. EACC, the chairmanship is not executive, and the commissioners do not do executive work. They cannot determine to charge anybody or to investigate anybody. That is a work done by management. Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, milady, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many, many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
We thank you, the Honorable, the AG, Senior Counsel. Thank you very much. At this juncture, I return this to the Judge President to lead the proceedings.
Yes. Yes. Thank you for that session. We are really mindful of the time today because we wanted to finish these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Rengo.
My Lady, the Chief Justice, before the main petitioners commenced their response,
Yes.
there were issues raised by the bench yesterday on which we were requested to provide answers today. At what stage will we be able to do that?
I think it is now. We must have forgotten you.
Thank you, Madam. Just give me 1 minute, I guess I know.
Can we give you 5 minutes to do that? I remember it was like 1 or 2 questions which were directed to you.
Madam, the dilemma I have is that there were about 3 questions raised,
Yes.
which I should respond to. But if you may recall, you had also permitted the advocates for His Excellency the Vice President to respond to the application by the Chief of Civil Service, Mr.
Yes,
Kenywa.
that is
And
correct.
they did that, and we didn't have an opportunity to comment on their response at all. So I will try to be very, very, as usual, very quick and respond in summary, but I will need about 10 minutes.
Okay.
And my other friend, Mr. Gatia, Senior Counsel, also tells me he has a request to make. Thank you.
Madam Chief Justice, you recall yesterday how gracious I was. I donated 32 minutes to court.
Are you claiming it back?
No. No, I will not do that because the court has work to do. All that I request is 5 minutes, nothing more than 5 minutes of your time. We are doing quite well this morning. Thank you so much. I don't know who will go first, whether it's my senior or ourselves.
I think you can go
Okay. Chief Justice and Deputy Chief Justice, members of the Supreme Court, just to point out that there were specific questions that were addressed, for example, to counsel acting for the 4 commissioners. And we would like to know at what point we are expected to respond to those questions. After the petitioners. Thank you.
Good morning, Madam Chief Justice and members of the court. I seek a little clarification because similarly we had several questions directed to us which we thought we would react to before we make our rejoinder. And I thought yesterday you had clearly stated that we'd have 30 minutes. We had about 27 questions. Are we at liberty to proceed to answer those questions right away?
Sorry, Senior Counsel Olengo, you have 1 hour to respond, but I hear you saying you need more than 1 hour because of answering the questions. And therefore you're asking for another 30 minutes.
With a little bonus.
We can see what we can do with 1 hour. If you extend maybe 15 minutes.
It would not be enough. There's a very important question which just...
It's all right, because even the time we are wasting now, you could be
minutes.
answering.
Yeah, so
Yes.
in the 30
It's just
minutes...
asking you to be kind, because we really have to get to the real business
Yes.
of writing the judgment.
Thank you.
And we
In
don't
the
have much time.
In the 30 minutes that we'll be answering those questions,
Yes.
my lady and my lords, you'll be addressed by my honorable friend, Mr. Otiende Amolo, particularly on the question of turnout, which was asked by Justice Wanjala, and Firoz Norji, Senior Counsel, Paul Mwangi, and Ms. Julie Soweto will address you in those 30 minutes. And I invite Senior Counsel Otiende Amolo to address you on the first question.
Yes.
Not yet.
Not yet. Not yet. Yes. Senior Counsel Oraro, please, or is it Gatia?
My senior is beckoning my team. You allow us?
Yes.
Chief Justice, Deputy Chief Justice, distinguished judges of the Supreme Court. Actually 3 questions were asked that are relevant to submissions yesterday, paraphrased as follows. 1, if the National Security Advisory Council 4 knew the results before they went there, and 2, why would the result not be announced the next day to build consensus, and 4, what would be the effect of the non-involvement of the 4 commissioners in the verification and tallying vis-à-vis Article 138(3)(c. Our response is as follows. 1, it is our submission that all factors point to an inescapable conclusion that the 4 members of the National Security Advisory Council, by the time they went to the Bomas of Kenya National Tallying Center, and by the time the head of public service placed a call on the returning officer of the presidential election, by that time they knew. And this is our evidence. By the morning of the 15th, letters had been issued by the returning officer of the presidential election, Mr. Chebukati, to all the presidential candidates and members of their family to be at the National Tallying Center for the declaration of results at 3 p.m. on that day. And my client already had received that invitation. I believe the other presidential candidates had those letters. And therefore, they knew by the time these 4 went, these state officers went to the National Tallying Center, they knew that the verification tallying had been completed, and what was pending was the declaration of the final result. It is our submission, Chief Justice, distinguished judges of the Supreme Court, that these 4 went to the National Tallying Center not for any other reason, but to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya, which had already been verified and tallied in accordance with Article 138(3)(c). 2, it is our response that the results could not be announced the following day because, according to the affidavit of the chairperson of the commission, and I'm using the word chairperson on advice by Justice Ndungu, which I agree with entirely, that by that time it was not possible for any form of consensus, because then the follow-up question was, I think from Justice Lenaola, why, for example, the returning officer would not have waited for an extra day, which he had, to build consensus on the 4 walk-away commissioners. It was not possible. It was very clear that the intention was to try and veto the will of the people, and therefore the chairman had to declare those results. Number 3, the 4 who left also, their colleagues had been injured. And so the chairman had, in our view, make the announcement that day because of the gravity of the situation. Finally, the question that this court ought to ask itself is whether the working away of 4 commissioners at the tail end of a process which they have admitted was complete, except the declaration, can veto the sovereign will of the people of Kenya. Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter? Thank you, and we prayerfully submit.
Chief Justice, my lords, Deputy Chief Justice, Lady Chief Justice, I'll begin with the question which was asked by Justice Lenaola, and that is, what orders are we seeking? The orders we are seeking is for this honorable court to dismiss the allegation by the second respondent on oath, which have not been accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, unless my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act, and Article 183, 3C, is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Onjala, and you